Good evening, all. Hope I'm audible. And welcome to the second edition of the Continuing Legal Education Program under the auspices of the Kerala Federation of the Women Lawyers. We are proud to present the speaker of this day. She is Advocate Indu Susan Jacob, a postgraduate in commercial law and criminal law. She started practice before the High Court of Kerala under the able guidance of Justice Betchu Kurian Thomas, presently Judge High Court of Kerala. She set up independent practice in the year 2011. She is a member of the Child Online Protection Team, a joint venture project of the Kerala Federation of Women Lawyers and the Kerala Legal Services Authority. And she's also an active member of the Victim Rights Center, again a joint venture of the Kerala Legal Services Authority and the Kerala High Court Legal Services Committee. Over to you, Advocate Susan Jacob. Advocate Indu Susan Jacob will present the topic of the day. Thank you.
Thank you, Parvati ma'am. Let me thank the executive members of Kerala Federation of Women Lawyers for arranging this session, and also all my friends who have joined to this meeting. Good evening to all. Now, the topic for today's discussion is Electronic Record and Indian Evidence Act. Now let's move on to the topic. The 21st century witnessed a rapid technological revolution. New communication systems and technology has made drastic change in the way we live. It provides opportunity to people across the globe to access any information, data, storage, etc. with the use of high technology. This increasing reliance on the electronic means of communication, e-commerce, and storage of information in digital form has resulted in a need to bring law relating to information technology and rules of admissibility of electronic evidence in litigations before courts of law in India. Thus, the proliferation of computers, the influence of information technology on the society as a whole have necessitated the amendments in Indian law to incorporate the provisions to appreciate the digital evidence. Now, the digital evidence or the electronic evidence or electronic form evidence, it means any information of probative value that is either stored or transmitted in electronic form and includes computer evidence, digital audio, digital video, cell phones, digital fax machine, etc. Now, this definition have taken from the explanation that is given to Section 79A of Information Technology Act. Now, the concept of electronic evidence was brought in by the Information Technology Act of 2000. Section 91 to Section 94 of the Information Technology Act brought in several amendments to various legislation. Now, as far as Indian Evidence Act is concerned, Section 92 of the IT Act brought in amendment to Indian Evidence Act. And the word evidence was amended to include the word electronic record. So let's go to Section 3 of the Evidence Act. Section 3 defines evidence. The evidence means and include oral evidence, which is all statements made by the witnesses which the court permits or required to be made in relation to matters of fact in inquiry. And then documentary evidence. All documents and electronic, including electronic, the term used is all documents, including electronic records produced before the court for inspection is documentary evidence. So we know that any electronic record that is produced before the court for inspection is a documentary evidence. Now, it is believed that the standard of proof of the authenticity and accuracy of electronic record has to be very stringent than the other documentary evidence. Because of that, two provisions, Section 65A and 65B, were incorporated into the Evidence Act. It was incorporated into Chapter 5 of the Indian Evidence Act. So now, if we have to, that is, admit any evidence in electronic form, any form of secondary evidence in electronic form, it is Section 65A and 65B that is applicable.
ഉണ്ടാക്കിയതാ ഇവിടെ ഈ ഇവിടെ നിക്ക അപ്പൊ ഇവിടെ നിക്ക അപ്പൊ
May I continue?
Yes. കുഴപ്പം എന്താ പ്രശ്നം കാവേരി സ്റ്റാർട്ട് ചെയ്തോ തുടങ്ങി പറഞ്ഞോളൂ സ്റ്റാർട്ട് ചെയ്തു.
Now here, so we have seen that these the chapter 4, chapter 5, two provisions have been incorporated. That is section 65A and section 65B, which deals with admissibility of electronic evidence. Now let us take a pause here. Now, before going into these provisions or the processes or the procedure that is laid down by the above mentioned provisions, I think it is important to advert to the Information Technology Act. I'll be taking to a few of the provisions which I believe is relevant and helpful for our discussion in the Indian Evidence Act. So let's go to the other act, that is Information Technology Act. Now, that is Information Technology Act of 2000. It gave legal recognition for the transaction carried out by electronic means. It gave equal legal treatment to users of electronic communication with other conventional forms. It legalized electronic signatures. It enabled the government to accept, file, create, and store data in electronic form. And also it set up various licensing and monitoring authorities. Then again, it has categorized certain acts as offenses under section 65 to 67B. But we won't be going through any of these provisions. I will be going only to a few of the definitions and also one or two provisions. So first, let's go to section 210. Section 210 defines electronic record. It reads as follows. Electronic record means data, record, or data generated, image or sound stored, received, or sent in electronic form, or microfilm, or computer generated microfiche. So it is basically data, record, data generated, image or sound that is sent or received or stored in an electronic form. That is electronic record. Another definition I would like to read out is section 2TA, that is electronic signature. Electronic signature means authentication of any electronic record by a subscriber by means of electronic technique. Like we sign on a document, that is, the authentication is done by means of electronic technique, then it becomes an electronic signature. Then another definition I would like to go to is regarding computer. That is given under section 2I. Computer means any electronic, magnetic, optical, or high-speed data processing device or system which performs logical, arithmetical, memory, and other functions. So it is basically electronic, magnetic, optical, and other high-speed data processing machine which does certain functions. That is also explained there. Now the other section is section 4. That is important. It is section 4 that gives legal recognition to electronic records. It says that wherever any law provides that information or any matter shall be in writing, then if that information is an electronic record, then this condition is satisfied. Suppose, that is, we know that the arbitration clause, it should be in writing. So if it is in an electronic record, then that requirement is satisfied as per section 4. The other relevant section is section 5, legal recognition of electronic signatures. Where any law provides that information or any other matter shall be authenticated by affixing signature, then if that information or document is authenticated by electronic signature, then that requirement under that particular law is satisfied. So this is
Indu, you have been muted. Unmute.
So I should repeat. So
Yeah, please kindly.
okay, so let me start from section 4, legal recognition. Okay, legal recognition of electronic records. That is where any law provides that information or any other document should be in writing. Then if that information or document is in electronic form, electronic record, then that's condition of the law is satisfied. So it gives recognition to legal records. Again, section 5, legal recognition of electronic signature. Now, here also, if any law requires that a document or an information has to be authenticated by a signature, then if such document or information is authenticated by electronic signature, then this above mentioned condition is fulfilled. That is the recognition given under section 5. Now let's move on to another important section, that is section 10A, that is validity as to contracts. Where in a contract formation, the communication of proposal, the acceptance of proposal, the revocation of proposals and acceptance, if they are expressed in electronic form, then it is considered as a concluded contract. If every part of every ingredients of contract, if it is in electronic form also, it gives recognition. That is, it is recognized as a concluded contract. Then another is section 30. That is the last session that I will be discussing is section 30. This is regarding time and place of dispatch, receipt of electronic records. Let's see when when we sent an email. What is the time of dispatch? Or what is the time of receipt? The section says that the save otherwise agreed between the parties, between the originator and the addressee. The dispatch of an electronic record occurs when it enters the computer resource outside the control of the originator. So when I sent an email and it reaches the computer resource of the other person, that moment it is said that that is the time of dispatch. So when is the time of receipt? It is said that if the addressee has designated a computer resource, he has given a particular computer resource, the moment the electronic record reaches that is the time of receipt. Now, suppose he has not given a designated, designated computer resource. Then if you are sending it to another computer address or computer resource of that person, the moment the addressee retrieves it from that address, that is the time of receipt. Then regarding the place is the place of business. Now, if there are more than one places of business, it's the principal place of business, and if there is no place of business, it's the place of residence. These are some of the provision which I thought would be relevant. Now, then I would like to. There's a case, Supreme Court decision, where these correspondence, that is with regard to it was regarding to a charter party agreement and also the arbitration clause in that. In that case, the court, that is by verifying the various email correspondence between the parties, held that these email correspondence will constitute a contract or an arbitration clause, and it was it was held so. That is in one of the decision, that is I'll give the citation, that is here. Every correspondence that occurred between the parties have been extracted, each email, and it has been verified. So it is very helpful to understand this topic as well. And also the point when the contract is accepted, or that is the proposal is, the offer is accepted, the proposal is accepted, everything has been explained. That is 2010. That is Trimex International FSC Limited Dubai versus Vedanta Aluminium Limited, 2010, 3 SCC 1. If you go through this, it will be very helpful to understand all these provisions that I have explained now. Now, I think it is time to go back to the Indian Evidence Act, which will be the topic of discussion for today. Now, let's start by reading section 59. Section 59 of the Indian Evidence Act. 59 says that all facts except the contents of documents or electronic records may be proved by oral evidence. It means that the contents of documents or electronic records can only be proved by documentary evidence. So the documentary evidence is dealt in chapter 5. So we know that the document is defined under section 3, but it should be noted that no amendment has been brought in to the definition of document to incorporate the electronic record. It is not there in document. So the document, that is the mode of proof of document is from 61 to 65. The 61 says that it can be proved that the content of the document can be proved by primary or secondary evidence. Then 62 says that is if you produce the document as such, it is a primary evidence. Then 63 says about the types of secondary evidence. And 65 says that the document has to be proved by primary evidence except in the cases below. And 65 gives us the cases below. But this is how usually the document has to be proved. But since the electronic record has not been made part of the definition of document, we have a special code in itself, that is section 65A and section 65B. So that is as far as electronic records are concerned, the admissibility can only be under these two provisions. Section 65A, it says that the contents of the electronic record may be proved in accordance of provisions of section 65B. Now let's go to section 65B. 65B is the provision which deals with the admissibility of evidence. Now this 65B has 5 subsections. Out of the 5 subsections, the first subsection is an enabling provision. And the subsection 2 and 4 are the most important one. That is where the procedure is actually laid out. And this subsection 3 is, it only clarifies us what is a computer, what is a group of computers, what is the combination of computers, etc. And subsection 5 is also regarding computer inputs and computer outputs. So we'll be dealing mainly with subsection 1, subsection 2, and subsection 4. Let's take we'll read the section answer, then we'll understand it better. Then I can go through the case laws and all. Now, section 65B, it starts with a non-obstante clause. It says that notwithstanding anything contained in this act, any information contained in an electronic record, which is printed on a paper, stored, recorded, or copied in optical magnetic media produced by a computer, even after refers to as output, shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information and the computer in question, and shall be admissible in proceedings without further proof or production of the original. It says that if certain conditions are fulfilled, then that electronic record will be admissible in evidence without further proof or production of the original. So this section is not dealing with the production of original document. So this is not primary evidence we are concerned. This is only secondary evidence. So section, that is the first point I would like to make. That is the section 65B deals with the secondary evidence of electronic records. It is not the primary evidence. Now, here it is said that the electronic record, which is in a printed form or a paper, printed on a paper, stored, etc., if satisfies a certain conditions, then it shall be deemed to be a document. So here, you should, that is, then I shall see, I have explained it earlier that in the definition document, there is no amendment has been brought in. So the electronic record is not, it's not defined under the document, it doesn't form part of the definition of document, but by deeming provision under section 65B, it is made a document. So this is a deeming provision also. Now it says that when certain conditions are fulfilled, then it shall be deemed to be a document and it can be admissible. So the conditions, what are the conditions? The conditions are that is given under the subsection 2. The subsection 2 say the conditions referred to in subsection 1 with respect to a computer output shall be the following, namely that the computer output containing the information was produced by a computer during the period of which that computer was regularly was used regularly for storing or processing certain information in the regular activity by a responsible person. So this is with regard to the computer from which that electronic record was produced. It should be shown that we have taken this electronic record from a computer, and that computer, that device was regularly used, and it was the information was fed to it in a regular course by persons responsible to it. That is the first condition. The second condition is that during the set period, that is the period when the information was recorded, the information of the kind contained in the electronic record or the kind from which the information so contained is derived was regularly fed into the computer. That is the relevant time when the information, that is the record that we are producing is produced, that the information was regularly fed into the computer at that point of time. And the other condition is that there was no material, the material part, that is computer was operating properly. That is the relevant period when we have taken that electronic record, that computer was properly operating. Or if it was not properly operating, then it has not affected the electronic record that we are producing. This is another condition. And the fourth condition is that the information contained in the electronic record reproduces or derived from such information that is fed into the computer. That is the information that we have is actually derived from the information that was fed into that computer. So these are the four conditions that has to be fulfilled before an electronic record can be deemed to be a document. And then we move on to the most important section, that is subsection 4. Subsection 4 deals with issuance of certificate. It says that in any proceedings where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things has to be issued. Now, what are the three conditions? That is, first, it should identify the electronic record. It should identify the electronic record containing the statement and the manner in which it was produced. If you are producing a pen drive, or if you are producing that is printout, that electronic record has to be identified, and the manner in which it has to be produced has to be stated in the certificate. The second is regarding the identity of the device from which we have taken that record. If you have taken that record from a computer in that office, then details of that computer in the office has to be given here. Then the third is all those conditions that is stated in subclause 2. That is, we have gone through the subsection 2, no? That is, only if those conditions are satisfied, the document becomes a admissible document. A deeming provision, that the 4 conditions we have gone through, no? That conditions has also to be stated in the certificate. Then the certificate has to be given by any person responsible, holding a responsible official position in relation to the operation of the relevant device or management of the relevant activities. And it should also be stated that all the above mentioned, that is statements, no, all the above mentioned information is stated to the best of the knowledge and belief of the person stating it. So these are the requirements that has to be there in a certificate that is to be issued under section 65B4. Now, here I would like to point out that in section 65.4, it is stated that the first part, that is, in any proceedings where it is desired to give a statement in the evidence by virtue of this section, a certificate doing any of the following things. It is stated as any of the following things. But so if any of the following things, that is, it is stated as certificate, it ought to have become a normal certificate. But unfortunately, the court has interpreted it in such a way that any should mean all. So only if the certificate contains all these conditions, then it can be considered as a proper certificate. So now we have gone through the provisions. Now, that is, by interpreting these particular provisions, there many issues have arisen, because we know that this particular, the procedure here is a complex procedure. Unlike what we have seen in, that is the other general provision, that is 61 to 65, 62 to 65, actually. This on the contrary is, that is, it has certain various procedures and conditions are laid down for just to make this electronic record admissible. These particular provisions. Now let's see some of the problems that was faced by. Now, the first question was whether the 65B is mandatory. That is, whether without this 65B, can the electronic records be made admissible? Then, because earlier there was a view by the Honorable High Court, Honorable Supreme Court, that we need not, that is, admissibility is not confined to section 65B. We can also prove the document by virtue of the other provisions, that is section 63 to 65. That is the normal provisions, no other provisions under section chapter 5. With that also we can prove this documents. But later on, the recent decisions, it has been held that this section 65B is it's a mandatory provision. That is, an electronic record by way of secondary evidence shall not be admitted in evidence unless that is requirements under section 65B are satisfied. So it is a mandatory provision. Now the next question is, and the reason it was stated is that 65A and 65B, they are special provisions. So we know that when there are special provision, the general provision shall yield to the special provision. So there will always be the primacy of the special provision. So you cannot say that, see, that also deals with proof by secondary evidence, section 63 to 65. So why don't I prove my document as per section 65 to 63 to 65? No, if it is an electronic record, you cannot do that, because there is a specific provision and it's a code by itself. You have to follow the provision, that is the condition that are stated here. Now, the second question would be whether the certificate under section 65B is mandatory. Now, this section 65B certificate, that the purpose is to ensure the source and authenticity of the electronic record. So it is for a particular purpose that this is provided for. That is, it is to ensure the source and authenticity of this, that is the electronic record. However, what happens when a certificate cannot be secured by a person who are not in possession of the electronic device? We know that this certificate has to be issued by the person that is in possession of or is responsibly managing that electronic device. For example, if it is a computer, who is responsibly managing that computer? So what if this was generated from some other computer? I am not the owner. I am not managing that computer. So I have to ask the other person to give a certificate. So what happens in that case? In that case, I can very well make an application to that person or an authority asking them to give a certificate in this regard under section 65B. So what if he refuses to do so? Suppose this evidence may go against him. So he may not be ready to give such certificate. So what happens when he refuses to give so? Then the court says that you have to make an application before the court. You have to apply to the court for its production. And suppose we make an application to the court and the court directs that that is the other person to produce it. But even thereafter, the other person does not produce the certificate. So in order to, that is, prove our electronic, we need that certificate. Suppose even after direction by court also, he does not prove that. Then what happens? Then the Supreme Court said that, then comes the application of the maxim, lex non cogit ad legem. It means that the law does not demand the impossible. That is, if then I have done everything in my capacity to see that I get a certificate. I made an application myself, he refused. I applied through the court, again he refused. Then it's almost impossible. Then you cannot, the law cannot make me do something that is impossible. And the court said that the mandatory provision of section 65B4 is done away with only in such situations. Otherwise, it is a mandatory provision. Only if these steps are satisfied, and then also there is no way we can get that certificate, then that mandatory provision is, you are relieved of that mandatory provision. Then another important the issue that always come up as far as this section is concerned, that is the production of the electronic record as a secondary evidence, is at what stage this certificate has to be produced. That is, at what stage if it is at the initial stage and we are not able to procure it at that stage, then can it be subsequently produced? So that is also another issue. That is, at what stage the certificate under 64B4 can be issued. The general rule is that the certificate must accompany the electronic record. That is when it is produced. That is when a person procures gets the information at that time itself. The certificate should also be procured from the authority or the person in whose control the device is. But suppose the certificate that was produced was defective, or for the reasons that I stated earlier, that is, for those reasons, I could not produce it at that point of time. Then the court says that you cannot deny the acceptance of that certificate. The requisite certification can be directed to be produced by the court at any stage, so that the information contained in the electronic record form can be admitted and relied upon in evidence. The court says that, so suppose the issue is, suppose we are not able to procure that certificate at a particular point of time, then even if it is a very crucial evidence, that cannot be looked into. So that is some injustice, no? So to overcome that, the court said that at any stage, you can produce that, provided the normal rule is that you should provide, you should produce it at the earliest. That is when the document itself is being given. But if for reasons as stated earlier, you are not able to produce that, then the court will not deny that. The court will allow you to produce it subsequently also. There is no bar. That is the point. The general rule is that you should produce it at the initial stage, but there is no bar. But there's also a caution that is given by the court. The court says that while allowing it subsequently, then there should be a balancing exercise with no prejudice for want of fair trial. That is, it should be allowed, but it should be allowed, that it should not be at the cost of a fair trial. That is the only condition. Now I have come across a High Court decision. That is, we have seen that the certificate has to be issued by a person occupying a responsible official position. Now, who is that is, if it is not a person who is occupying official position, then from whom we should get that certificate? Here it has, this particular part has been interpreted by the Delhi High Court in Kundan Singh versus State of Delhi. And that part is it. That is, and I give you the citation, 2015, so SEC Online Delhi 13647. 2015 SEC Online Delhi 13647. Here it says that the person occupying a responsible official position actually means person primarily responsible for management or upkeep or operation of such device. He need not be the official. That is, it says that it only means that any person who is primarily responsible for the management or upkeep of the operation of such device, then he can issue a certificate. So Now, these are some of the issues that I've seen in many of the cases. So I thought I will enumerate it and so I can clarify that point. Now we can see we can go through the important case laws in this particular field. Now, the first one is Navjot Santhu case. In Navjot Santhu case, which is the citation is 2005 1 SEC 600. This is the Parliament attack case. In that Parliament attack case, regarding the electronic records, the court held that, the apex court held that if certificate is not filed under section 64B4, then there is no bar to adduce secondary evidence under section 62 to 63 to 65 of the Evidence Act. So that is earlier we discussed, no? So this was the position earlier. Suppose you are not able to produce a certificate under 65B4, then there is no bar to adduce your secondary evidence under section 63 to 65. That was what held by the apex court at that point of time. Now, interestingly, that held the field for almost a decade. It was in the year 2005, but this position was overruled in the year 2000. That is 2014. That is Anwar PV versus PK Bashir. Anwar PV versus PK Bashir, the court held that any documentary evidence by way of electronic record can only be proved in accordance with the procedure under section 65B. It was in this that is judgment that the court held that 65B and 65A are special provisions, and when special provisions are there, the general provision has to yield to the special provision, and this will have primacy. It is a code by itself, and it is only according to this an electronic record can. So this position in the Navjot Sandhu case that held the field for 10 years was overturned by PV Anwar case. But even after PV Anwar case also, another case that is Shaji Mohammed versus state of, that is Himachal Pradesh. That is a decision in the year 2018. 2018 2 SCC 807. In that case, that is subsequent to the PV Anwar case, the apex court held that in case an electronic device is produced by a party who is not in possession of a device, applicability of section 63 and 65 of Evidence Act cannot be excluded. So here, when Navjot Sandhu, it was held that simultaneously you can either make it admissible under section 65B or you can go to section 63 to 65. But in the Shaji Mohammed case, the court said that if the device is not in your possession, you are not able to get the certificate, then the section 63 and 65 cannot be excluded. In such situations, 63 and 65 cannot be excluded. But this was actually against the principle laid down in PV Anwar case. PV Anwar case is a three-bench decision, while the Shaji Mohammed is a two-bench. Now, thereafter, the recent one, the latest one, decision that now holds the field is Arjun Pandit Rao Khotkar versus Kailas Kushan Rao. These are all election petition cases. The PV Anwar case was also an election petition case. PV Anwar's case, it came from the state of Kerala. And the election petition was filed to set aside the election, but it was basically on the basis of certain announcements and songs. But these announcements and songs, which was recorded in the CD, for that CD, CD was produced an electronic record, but it was produced without producing the certificate. Then the High Court rejected it, saying that cannot be accepted, and rejected the election petition. When coming to Supreme Court also, it came to Supreme Court in appeal, the Supreme Court also held that electronic record by way of CD and VCD can only be proved if there is an accompanying certificate. Without the certificate, we cannot look into it and dismiss the petition. Now, coming on to the latest, that is the Arjun Pandit Rao case. That is the citation is 2027 SCC 1. This is the latest one. This holds the field now. 2027 SCC 1. Here, this was referred because we have this Anwar's case, that's a three-bench. There was another three-bench decision that is 1985, where also it is said that you can produce the secondary evidence of electronic records by virtue of section 65. So there was one such 3-bench decision. Then again, we have the Shaji Mohammed case, which we discussed here. These were against the, that is principle laid down Anwar case. So this matter was referred to Arjun Pandit Rao. And Arjun Pandit Rao upheld the position, the finding in the Anwar case, and said that this is a mandatory provision and it cannot be. It was in this case that the earlier points that I have discussed, that is with regard to that is the stage at which the certificate has to be submitted, etc., was laid down in this particular case. And also another Pandit Rao case, it also interpreted the certain provision. As I that is told you earlier, under section 65 subclause 4, I said that the term any was construed as all. And again, the court held that there is no bar in producing primary evidence. If you have a laptop or computer and you produce that laptop or mobile phone that itself to the court, then it becomes a primary evidence. Then there's no requirement to be satisfied under 65B. 65B is only as for secondary evidence. So that the court said that if you have to produce the primary evidence, you just produce it, and then the whatever that you have, the laptop, the tablet, the mobile phone, etc., you produce it, then step into the witness box. That's the only requirement that is there if it is a primary. All these procedures are there only for the case of secondary evidence. Now, I think these are the main case laws as far as this particular section is concerned. Now I would like to take you to a few of the other provisions of this Indian Evidence Act, which are also relevant. That is section 45A. Section 45A. It says that when in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, then the opinion of examiner of electronic evidence is a relevant fact. So in the case of electronic record, then the opinion, the expert opinion is the expert opinion of an examiner of electronic evidence, that as given under section 79A. 79A of the Information Technology Act, the central government notifies us certain department or agencies of the central government or the state government to be the examiner of electronic evidence. That person can be, the opinion of that person only can be taken under section 45A. The next is 47A. Opinion as to electronic signature. When the court has to form an opinion as to electronic signature, the opinion of the certifying authority which has issued this relevant fact. That is, I just want to mention some of this that is applicable here. Then again, we go to 65A. No, 67A, sorry, 67A. Proof as to electronic signature. Except in case of a secure electronic signature, if the electronic signature of any subscriber is alleged to have been affixed to an electronic record, the fact that such electronic signature is the electronic signature of the subscriber must be proved. That is, this is regarding to how the electronic signature can be proved. Then we have the 81 is important, 81A. No, it's not 81A, that is 85ABC. 85ABC. Presumption to electronic agreements, 85A. The court shall presume that every electronic record purporting to be an agreement containing the electronic signature of the parties was so concluded by affixing of the electronic signature. So there's a presumption. When an electronic contract is entered into with the signature, it is said that it is presumed that the parties have so concluded the contract by affixing the signature. Then we have, that is the presumption saying, that is presumption as to electronic signature certificates, except that is 85C, and presumption as to electronic records and electronic signature. So these are some of the other relevant, that is with, as far as electronic records are concerned. I think I've covered the entire matter. Thank you.
Thank you, Susan. It was we have covered almost all the relevant provisions. I think section 65B, the certificate under section 65B was a very relevant thing regarding many issues, both civil and criminal, civil matters especially. So any queries from anyone? You can have an interaction with her as well, with the speaker as well.
Yes, Parvati ma'am, I have one doubt.
Yes, you can ask it to Susan.
Good evening, Susan madam.
Good evening, Surya.
Ma'am, my doubt is that in the absence of any certificate under section 65B, can the electronic document be proved by oral evidence or any other expert evidence?
No, it cannot be. It cannot be.
Is there
That-
another?
That is, you're saying that is whether the other provision, the general provision, that is 63 to 65 is applicable.
65.
Whether it can be proved by 63 to 65.
Fine.
No, it cannot be, because as I stated earlier, the Apex Code has stated that as far as electronic records is concerned, it is a special provision that is 65A and 65B. That can be that is applicable in electronic records. The other general provision will not be made applicable, because whenever there's a special provision, it shall have primacy over the general provision, and it is a code by itself, and it can only be proved by section 65B and 6. And the only exception is, I mentioned, no, when you do the 3 steps, that is, you are not able to procure the certificate. You make an application, then also you don't get it. You can make an application to the court, then also then it becomes impossible. Then you are relieved of that certificate, but you cannot go to 63 and 65.
Thank
You
you,
cannot
ma'am.
bypass. You cannot bypass, right? You
Yes.
cannot bypass.
Yes.
Into Susan.
Yes.
I'm Sally here.
Yes, ma'am.
I just wanted to ask you, like, suppose the WhatsApp messages, the messages that are conveyed, a communication sent between the parties through a mobile WhatsApp, you can take the printouts only after, sending it to the mail ID and convert it into a hard copy.
Yes.
What will be the position of that messages?
See, I have seen a recent Supreme Court, but in the Supreme Court decision, there's no evidentiary value to WhatsApp as such. But I have gone through that order, but it was no discussion on that. It was, I think, based on an interim order that court has given such an observation. That was not the final judgment. But what I understand is that even notice by WhatsApp is permitted by court. Notice by WhatsApp is permitted by court. So if that is, if you take, that is the that is Arjun Pandit Rao case. If it is laptop and mobile phones and not, if you receive that information in your device, you can either give it to the court. Then that itself is a primary evidence. If it's
suppose you are not in a position to give the devices to the court, will this certificate will be sufficient?
Yes, that the person responsible, that it has not been explained by the Apex Code, but it has been that it was by Delhi High Court, which said that the person who has the primarily managing that device can issue a certificate. Of this is only with regard to the admissibility. Of course, once the document gets admitted, then the genuineness and everything comes. Then that part is there. Suppose somebody object to it, then the genuineness of that has to be proved otherwise. This is only with regard to the admissibility. How can this be made place before the court? It can be made admitted before the court.
So
I think I can
ask
add to
that. Adding to that, may I ask how it would be? The question was, if it is a message that has been received by A on the phone as a WhatsApp message. Now, what Sally ma'am said is that we can print it out only by sending it to your email and then taking a printout of that email, because from a WhatsApp you cannot take a printout. I mean, that's what I understand.
Yes.
So then the machine from which you took a printout is naturally a computer or a laptop.
Yes.
So it has to be a certificate issued by the person in charge of that computer or that
Computer.
laptop. Am I right? Not
Yes.
the person whose phone in whose phone that message came. Am
But
I
the
right?
certificate should include the details of the phone as well.
Phone,
Oh, I see.
phone, computer, and things like that. No.
The person who has been
No, but
handling it.
suppose I get a message. I don't have a computer. I don't have a computer. I approach B and I say that, see, I have this message which is obnoxious. I want a printout of it so that I can complain to the police. So then I'm forwarding it to B, who has a computer, and he takes a printout and gives it to me. So he has to give a certificate saying that
he has received this message. It was forwarded to his mail from such and such a phone of this make, of this kind, whatever. The details of the phone has to be included in that certificate.
Yes. Yeah, for example, I would like to say that suppose
you have one second, you mean to say that you have to give all the details of the device, phone,
yes, all the details of the device, and also a declaration to the effect. I'm sorry, Susan, if you can correct me if I'm wrong.
You can, no, that is correct also. You can say. No problem.
What I understand from Susan's class as well as otherwise, I think you have to give a declaration that the device has been functioning properly so far, and you have been regularly using that device as well. So the information that has been transmitted from that device is proper and correct. Isn't it right, Susan? Subject to your subject correct.
Yes. So I would like to that is clarify one more thing. That is in the that is certificate in the that is section 65B. We stated that you have to identify the device. And also in another aspect, it was said that the police had certain information in a pen drive. It was sent to the examiner. Now, examiner took that in another CD for examination. Then he produced that CD. For that CD, the certificate of the examiner has to be again given.
Okay.
In one particular case, it was the police has to get the certificate from where he has taken the initial information. But when it is copied to a CD for examination by the examiner, again, he has to say, they give the details. From this, I have done this, and this is the certificate I'm issuing. That was discussed in one of the High Court cases. I have it. I don't have the citation now, but it was there. So he has to again give a certificate.
So all the procedures through which all medium it passes has to be clarified. Yeah.
Yes, what I understand is there's a change of hash values also in the case of these, when it is being cloned or when it is being.
That is one of the important thing is that hash value is, so that is like we measure something. That is, if you have 1 kg of rice, that is, the measurement is 1 kg. Like that for any electronic record, that is, you can have the hash value. So we encrypt the record and we send it to other person. If the other person checks the hash value, suppose if there is any, if I write it that Indu Susan Jacob dot, then if somebody intercepts and put it like Indu dot Susan Jacob, then when they verify the hash value will be different. The hash value will be different. So that these are all there. The forensic, for the forensic part, these are all there. Like the digital signature, we have the private key and the public key. The public key for verification, everything is there. This hash value is something very important. And also the certain details, electronic details that we get regarding electronic records. If that details is also put in that certificate, that is, it will be more valuable because those things you cannot change. This hash value is also very important. So that is for the defense side also. That is very good for the defense side. Unless the prosecution proves that the hash value at this time and the subsequently, when it was brought before this, if it is not the same, it means that it was tampered with. The document was tampered with.
If the original gets tampered, the hash value definitely changes.
Even a small change, that is, if we rearrange the things, any change, minute change comes, hash value changes. That is a very protective thing, that is hash value thing.
I think we must have a class on the forensic side of it also.
Exactly, definitely.
Yes.
We should have it also.
Because
electronic terms, technical terms, everything should be.
now we are only at the at the tendering of evidence stage.
Yes.
Now, how does this come out in a trial? That is something which will be
Yes,
very
that
interesting.
itself, I think, may take 1 or 2 classes. And one more thing I would like to point out that, so these sections we have mentioned, no, it was incorporated from the UK legislation, that is Civil Act as well as the, that is Police Evidence Act. But those 2 provisions have been, that is omitted way back in 2000 itself. That has been repealed way back in 2000. But we are still following that. There, the Law Commission report said that the electronic record should be made admissible like any other evidence. You need not put these complex procedures. But here we have complex procedure and the provision, and also the court has interpreted in such a way that it has become it is stricter also, more complex.
Don't you think that such a strict interpretation is actually going to stand in the way of achieving justice? In the sense, like a country like India, where your the penetration of electronic devices in the entire country is not as good as in any of the westernized countries. Don't you think it's going to create a lot of problems for common man to come up with electronic evidence? Because if such strict evidence is going to be insisted on,
Yes, but
don't you think we should also follow UK by scrapping
definitely.
that extra certification and things like that?
Yes, I think so, because from that is from Navjot Santhu's case, it took 10 decades to come to this, that is PV Anwar case. I think that within a few years, they will let go this provision also, because as discussed earlier, the electronic records itself has many protective things inside it, where nobody can change it. That is like hash value and everything that is protected. So let us be why we are giving different treatment to electronic records. It was it was mainly given because it was thought that it is susceptible to tampering. But now when we have devices to that is to prove whether it was tampered with or not, the only thing is that you should be more aware of whether everybody can will have that knowledge. That is, for example, the forensic side of it. That is if only we enter everything in the certificate and everything will be helpful, no? So whether common people will have that knowledge is another thing. At least the lawyer should have. They should be trained.
And we are getting the information.
Yes, we should be trained at least in this regard. Then it will be.
Because finally it is that which the forensic value will definitely have the impact on the trial's outcome, isn't it? So we should get actually lessons in forensic side of letting in electronic.
That is very important now. I think very important, because unless we know that, we cannot properly, that is, they produce these electronic records, because somebody has the more knowledge about it, we can easily lose the case just because we are not aware of those things. That is that kind of knowledge, forensic part of this electronic records.
Ma'am, I have a doubt.
Okay.
May I? Hello?
Yeah, I can hear you.
Yeah, ma'am, what I'm telling is that as we discussed in the beginning, that by 65B, the admissibility and of the electronic record by way of secondary evidence is being ascertained. So, or made sure. So in that scenario, because it is secondary evidence, the printed documents, for example, WhatsApp chats, if screenshots are being taken and then it is accompanied by 65B4 certificate, then it becomes a secondary evidence. So in that case, is for making that secondary evidence a primary evidence, is the deposition of the instrument in the court necessary for forensic?
Yes, that is, that is primary evidence is when if I get your question correctly, that is if the device which produced that information, if that itself is given to the that is court, then it becomes a primary evidence. Then you need not get all the certificates.
But there are times when the client, for example, says that at this point of time, filing of the complaint or filing of the suit, at that point of time, the printouts of those screenshots or exported chats are being filed with the 65B4 certificate. Yes. During the trial, when evidence starts, at that point of time, the other side files application for deposition of that mobile, for example, with the client. Then then that is mandatory, or will my certificate suffice as secondary
No, I didn't
evidence?
get you. Come again. I didn't get you. That is, you have filed. You have only produced the copies from the messages as such. You have not produced the document.
Ma'am, what I'm trying to say is, for example, while at the time of filing of a suit, I
Yes.
want to rely upon a WhatsApp chat
Okay.
communication between
It's breaking.
two people.
When you repeat, it's breaking.
What I understood from what she said is that suppose a client produces the printouts of whatever is the material on which they are relying, along with a 65B certificate in the
Yes.
court at the time of filing the plaint. But at the time of trial, if there's an application by the defendant saying that you deposit the original the machine or the instrument, then what happens? And if you actually produce the instrument, then will the primary evidence be relied, or will you go by the 65B?
Well, of course, the primary evidence is there. That is the best evidence, no?
So that's what she wanted to know. With the
only
suit she has produced,
of course, whenever the primary evidence is not possible, then comes the secondary evidence. So if you have the primary evidence with you, that is the best evidence.
And what I understood that what she was asking is whether this is Asha, Susan.
Okay, Asha.
What I understood that is it proper from the side of the defendant to insist for the primary evidence when they have already adduced the secondary evidence? Why secondary evidence is reducing? Because the primary evidence is not available.
Yes,
That is why.
Yeah. Okay.
Yeah.
Okay.
So is it proper from the side of the defendant to insist for the production of the primary evidence itself? That is what I think she is asking.
No, there's no need. That is if there is a proper procedure for proving a particular information or a document by of secondary evidence, and we have followed that procedure, then that he cannot. What is the purpose? He can challenge the genuinity of that. Then we will suffer. But why? How can he insist for the prime? That is what kind of evidence that we have to produce?
Susan, can I ask you a question? My doubt is whether while producing such a secondary evidence, is it necessary for the party who is adducing the evidence to give a declaration that primary evidence is not available? Is it such a?
But that requirement, that is the fundamental requirement as in 63 to 65. That is not there in this particular 65B. But having said that, because see 63 and 64 it says that the primary evidence has to be produced unless it is as per the following cases, then 65 comes. So there, by statute itself, we have to first prove that we are not able to produce primary evidence for so and so, and hence we are producing secondary evidence. That is because that is there from 62 to 65. That is the requirement of 62 to 65.
Exactly.
But that is not there under 65B. Having said that, that is in Arjun Pandit Rao's case, the court said that whenever it is a laptop, phone, and other devices, you give that, and that is you give it as a primary evidence, and you that is mount the witness box. Only when it is a that is a computer network, or there is a group of computers, combination of computers, which makes it impossible to produce it before the court, then you can that is secondary. But whether the other rule, that is 63 and 65, that is not discussed there. But I think because of the specific provision under 63 and 64 and 65, that we have to comply with that.
Okay.
That is what my understanding is. 65B does not say so. It just says that that is the beginning part. It says that if you produce an electronic record following so and so condition, here the condition is as per subsection 2. No other conditions are there. If you produce a computer output by complying with the condition under subsection 2, then it becomes admissible.
I do think it is right, because in section 65B, going by the wordings also, you are right. Because what it has been stated, I will read the relevant portion. if the conditions mentioned in this section are satisfied in relation to the information and computer in question and shall be admissible in any proceedings without further proof or production of the original.
Yes,
Very clear,
origin.
very clear.
Yes, that's the reason why even bank statements, I think when we give bank statements in civil matters, we give a 65B certificate. Because
I was about to say that same thing. Because they can't, I mean, the manager who is responsible of having custody of the software, he will be giving the
65B certificate.
65B certificate is given.
I have just another, I'm just thinking, as that Ms. Dikshit asked a question. See, given our situation in India, we file a suit in 2022. It might come for trial after a few years. So suppose I have a laptop in which all the contracts and, mails and everything has come. My client does not want to deposit he has the primary evidence, no doubt. He has this computer where he has got all the emails which he had with the buyer or seller or whatever and contract. And then he doesn't deposit the primary evidence, but he gives all the printouts with the 65B. But when the matter comes up for actual trial, I do have a primary evidence. I mean, that client has the laptop. So can he substitute by bringing his laptop and using that?
It depends. It depends whether if that evidence can be, there is the particular stage at which that evidence can be taken, no? If that particular stage, that you say that you are producing the primary evidence, then there's no bar. That is the only thing that you cannot, that is that the other provision, that is the certain conditions are stated in 63, 65, no, where the secondary evidence, and then you have to prove before the court that those conditions prevail. Hence, I am producing the secondary evidence. That is not here. That is not here. So if as
because practical point of view, I'm asking you, suppose you have a computer or a mobile phone or something, I mean, you wouldn't want to put it in the court for years together.
Unless it is a document that ought to have been filed along with the plaint, then you
if this is the basic document, yes, on which you're relying on, suppose it's an international contract and you've been, back and forth, you have been sending mails, and finally the consensus has come. So as you said, the dispatch, everything is there by looking into the emails. So when you want to prove it to the court, we can only take a printout of all these and give to the court.
Then emails and all, I think if there is digital signature and everything, that itself, I think, is enough proof. If digital signature, it cannot be changed anyway, no? There's a trail that can be verified, and there's a trail. That is, so that also comes as a secondary evidence. But you're saying that suppose I want to produce the laptop as such, the device where from that is, I think, I don't know. That is, maybe that can be.
No, so Susan, can I interrupt?
Yes.
I think Kartika was talking about a personal computer from which it is being transferred to the, all the mails are available on the laptop as well.
Yeah.
So if you have given a 65B certificate vis-a-vis your personal computer, whether your laptop can subsequently
be produced at the time of trial
as a preliminary evidence.
Because I'm saying, because we don't have a trial immediately on filing any case in India.
Something I think which the court will have to take a call on, because
you have a trial after so many years. We know our conditions in court where you deposit all these electronic documents. We never know in what condition it will be by the time the trial comes.
I think yes, it is the discretion of the court. The court
it will depend on how the court takes, because again the device has changed. Of course, there has not been any tampering because it remains in the mail itself. But the device has changed.
No, device has changed. It is the computer
is the same device.
Same
you
device.
Said about the laptop. You said something about the laptop.
No, what I'm saying is in a civil suit where we are on a contract, all your mails are coming in the laptop, and you've accessed it. You've taken a printout and given under 65B certificate. Now, at the
later
time of
at
trial,
some point too, from the same.
I don't have to
substitute from the same device. If it is so, you can always substitute.
Because in India we cannot trust and give.
Perhaps
all
they will examine. They will examine
and
whether it's the same device from its number and things and all that stuff.
Yeah,
they will just examine whether the 65B certificate corresponds to the same device.
Yes, when the device itself is given, then comes the other part of evidence, whether the genuineness, that is always there. Once it is admissible in evidence, the other part of the evidentiary process, that continues. but it can be taken in evidence, I think. That is better because all these procedural complexity is not there.
Yes, exactly. That will be much better.
Yes.
But you know, the conditions in which our MO objects are kept in our civil codes, do you think, you know, keeping these sort of electronic devices, it won't be dangerous?
Yes, that is another aspect. That is when you,
because you're talking about after 2 years or something, the trial, if it posted for trial, I mean, your laptop, we don't know in what condition it is.
so that we need to produce only at the time,
Only at the time of
marking.
evidence. Only at the time,
Only at the
when
time
it's
of
being
evidence
marked.
marking, you know, that is then
We
only
produce it along with the plaint.
Yes,
And always produce
that
it at the time of
photocopy, that is like that is photocopy can be
It's
produced
like
then at the time of the original can be.
yes.
Just like the
we need not go by
can file it.
65B. We need not go by 65B. We can just directly give our the original computer. And
Then this
There's no question of 65B yet now.
Yes, 65 feel that we are escaped from 65B.
And
Yes.
what I understood that when criminal matters are coming, if we use any electronic device for the commission of the offense, then definitely it will come as a M only. It will as a material object only. But
it will be
still then,
confiscated by the police, isn't
but
it? at
still
part?
then, but the contents of the document can be produced only in accordance with 65. Content of the document can only be, that is what I understood. I'm right, Susan?
I think there is a clarification because in Gopalakrishnan case, that Dilip's case, the Supreme Court said that when you, it is different thing, material object and that is documentary evidence, there are two things. Now, if you don't want to prove the content of a particular for example, somebody your mobile phone is stolen. The police finds out and it gives as that is produce it before the court. That is a material object. But suppose you have to prove some information from a mobile phone, that is another scenario. Then that becomes a document. Then that is not a material object. That can be that is all that is only a document. That is not a material object. That is material object. That is the physical condition only. You cannot look into the content or anything of the material object. That is form part of the that is offense. But for example, the example that is given, your mobile phone is stolen. The police retrieves it, and as a material object, he gives it to the court. That is the only purpose. But suppose in the case of there is something we have to prove from the mobile phone, then it can only be an object. That is document. Can only be a document. Can be marked as 65B. That is that also that is the very nice decision of the Supreme Court because we the Kerala High Court decided otherwise. The Kerala High Court decided it as a material object. But when it went in appeal, the Supreme Court said that it is not material object, it is a documentary evidence. Then 65B certificate is important. That is Gopalakrishnan's case. I have that citation. Dilip's case only, whether
in the first round.
That is whether the question was, if it is a material object, then the copy need not be served to him. But if it is a document, then by the time of that a final report is produced, then all the documents has to be served to him also, being the accused. So that in that case, this has been discussed. That's material object.
Citation, Susan, it's a very important decision.
And earlier, Susan, I think what the decision first one was quoted is regarding to the Justice Abraham Matthews decision.
Yes, Abraham Matthews, yes.
Sharon B. John versus State of Kerala. In that case, it was discussed whether the accused is entitled to give to get the documents of the CD, where it was told that it's the material object. Am I right?
That has been reversed by the Supreme Court in Gopalakrishnan.
Yeah, reversed by the Supreme.
That has been reversed. So I had that. Can I give you the citation later because I cannot find it.
Yes. You can post it in the group.
Okay. I'll do that. That is a very interesting decision. That is very interesting decision.
It was an excellent session. We really enjoyed the interactive part of it more because, I mean, these are doubts in the minds of most of the practicing lawyers. So how do we go about it and things like that? That's what brought us to this topic itself. Thank you very much, Indu.
Okay.
Thank you, Indu. It was wonderful. It was wonderful.
Let me give the citation. I have that citation.
Yes.
That is Gopalakrishna P versus State of Kerala. That is AR 2020 Supreme Court 1. whether memory card and pen drive were document or material.
Very wonderful session. It was a brainstorming session, and all of us enjoyed because it was more or less it was an interesting interactive session, and we expect to have more classes like this by the continuing legal education program under the auspices of the Kerala Federation of Women Lawyers. So thank you one and all. Grateful to all for the interactions and for the suggestions and for the clarifications on the subject. Good night and have a very wonderful weekend.